चल આવું કરો ને આવો રાખો છે ચા કોફી લેશો મને તો એવું કીધું તમે અંદર નહીં કહી શકો ચા કોફી નાસ્તો છે તમે હવે એને તો નહીં કહી શકો કે તમે મને કીધું પણ તને કહેવાય મને ખબર નહીં સાહેબ બોલાવશે મને કહેવાય Good morning, Good morning. How are you? Fine, good to see you. Arre, thank you, sir. Kakkar sahib, કેમ છો? I'm lovely to see you. કેમ છો તમે? મજામાં છો? હા જી, મજામાં છે.
Welcome you all on behalf of Justice P.D. Desai Memorial Lecture Committee and Praleen Public Charitable Trust to today's memorial lecture to be delivered by Honorable Mr. Justice Rohinton Nariman, Judge, Supreme Court of India.
Begin this auspicious occasion, may I request Shri Amar Bhatt, Advocate, to offer prayer. Amar Bhai has selected one of the masterpieces, Shabad Sadhana Kije, from the treasure of Sant Kabir's creations, where Kabir has tried to explain power of words.
संयुक्तं नित्यं ध्यायन्ति योगिनः कामदं मोक्षदं चैव ओंकाराय नमो नमः ओंकाराय नमो नमः साधो साधो शब्द साधना कीजय साधो शब्द साधना कीजय जेहि शब्द ते प्रगट भय है सोई शब्द ग्रही लीजय साधो शब्द साधना कीजय साधो शब्द साधना कीजय शब्द वेद पुराण कहत है शब्द वेद पुराण कहत है शब्द सब ठहरावे शब्द सुर मुनि संत कहत है शब्द भेद नहीं पावे, साधो शब्द साधना कीजे, साधो शब्द साधना कीजे। शब्द सुनी सुनी भेख धरत है, शब्द कहे अनुरागी, शट दर्शन सब शब्द कहत है, शट दर्शन सब शब्द कहत है, शब्द कहे बैरागी, साधो शब्द साधना कीजे, साधो शब्द साधना कीजे। शब्द माया जग उत्पानी, शब्द केरा पसारा, कहाँ कबीर जहाँ शब्द होत है, तबन भेद है न्यारा, साधो शब्द साधना कीजे। जो ही शब्द ते प्रगट भये हैं, जो ही शब्द ते प्रगट भये हैं, सोई शब्द ग्रही लीजे, साधो शब्द साधना कीजे, साधो शब्द साधना कीजे।
Gods are pleased with the offering of flowers, and so are the human beings. On behalf of the Trust and the Lecture Committee, I would like to welcome our honorable guests with presentation of bouquet.
May I now request Ms. Darshini Pathak, trustee of the Praleen family, to offer flowers to the honorable guest, Honorable Justice Nariman, Judge, Supreme Court of India.
May I now request Ms. Saloni Shah to offer flowers to Honorable Justice Shri R. Subhash Reddy, Honorable the Chief Justice of Gujarat High Court.
May I now request Ms. Hina Rana to offer flowers to Mrs. Sanaya Nariman.
I may now request our honorable guest, Honorable Justice Rohinton Nariman, Judge, Supreme Court of India, to enlighten us on today's topic.
Chief Justice Reddy, Honorable Judges of the Gujarat High Court, Kamal Bhai, thank you for everything you said about me. I don't believe a word. Suresh Bhai, Nirupam Bhai, my dear friend Dushyant, ladies and gentlemen. Today's subject takes us back to the year 1787. As Suresh Bhai Shelat told you, these are the words of a man who was only 30 years old at the time he wrote them, Alexander Hamilton. The Federalist Papers, and these words are from paper number 78, which is a very famous paper, were basically crafted by three very great people. The youngest, Hamilton himself, who wrote 51 out of 85 of them. The second, James Madison, who was the fourth president, also called the father of the US Constitution. And the third, John Jay, who became the first Chief Justice of the United States Supreme Court. Now, what is interesting is that these papers were written in order that the state of New York, which was one of the 13 colonies, so to speak, which formed the United States of America, ratify the US Constitution after it was drafted. There were various drafts which went through, but the basic draft was the Virginia draft of James Madison, which is why he is called the father of the Constitution. And in order that New York ratify the Constitution, it required the persuasive powers of one of its youngest subjects, Hamilton, aged 30, to tell the state of New York what this new constitution was all about. And in telling them what this constitution was all about, he basically told them that there were three great divisions of power. And he used this expression, the least dangerous branch, because at the time, he said it was the least dangerous to the political rights of the people, being in the least capacity to annoy or disturb them. These are his exact words. And he said, when you compare the judiciary with the legislature or the executive, the legislature has the purse, dispenses the honors. The executive holds the sword. But what does the judiciary have? Only judgment. It has neither force nor will and must depend for execution of its orders on the executive, which is why he also called it, dubbed it, the weakest branch of government. Now, as I told you, these words were spoken way back in 1787. But what he said came to pass almost immediately thereafter. There were two examples, one interestingly enough in Bombay, and the other, the US Supreme Court itself. Chronologically, the Bombay example comes first. In Bombay, a Supreme Court was set up by the East India Company in the year 1824. And that Supreme Court, unlike our Supreme Court, had very limited powers. It could only deal with the Principality of Bombay itself. It consisted at the time of a Chief Justice, West, Judge Chambers, and Judge John Peter Grant. Chambers, unfortunately, did not get on with the then governor, a man called Mountstuart Elphinstone, and also ran into members of the bar because he refused to buckle down when the bar asked him not to fix a scale of fees for them. Ultimately, he went ahead, fixed the scale of fees. The bar protested. He didn't bother about the protest and told the attorneys to come and argue before him. But all this took its toll on him, and he died at the young age of 45. That left two of them, Justice Chambers and Justice John Peter Grant. Interestingly enough, by then, the governor also changed. And one John Malcolm came, who was a 6-foot-something Scotsman, tall, ferocious, and difficult. And a petition was filed by a suitor from Pune, asking for a habeas corpus to get back his nephew, Moro, some young boy of 14, who was also in Pune. This habeas corpus writ was granted by Justice Chambers and Justice Grant. Governor Malcolm insultingly told all those who were supposed to execute the order not to execute it because it was without jurisdiction, and sent an insulting letter to the judges, which was read out in court. Incidentally, it was read out in a building which still exists. If some of you know Bombay and you've seen Lions Gate, there is a very, very old building with massive archways, which was the old Supreme Court building in which this was done. And when read out, it was in an extremely insulting tone to the judges. It spoke down to them. Justice Chambers, on this letter being read to him, felt extremely agitated and then made a very famous statement that at least in this courtroom, there is nobody above us except God and the king, and sent back the writ to be enforced. 2 weeks later, Chambers died, which left only poor Justice Grant. The writ was unceremoniously sent back, and as a result, Justice Grant locked up the Supreme Court and set sail for England. However, the matter didn't end there. What happened was that a complaint was made by the governor, mind you, not by the judge, to the board of directors in England. The board of directors referred the matter to the Privy Council. And the Privy Council, surprisingly, took the side of the governor and then said, yes, the order was without jurisdiction. And then ultimately it was decided that since Grant was going to go back and sit as one of the 3 judges, the board said, we will need 2 tame elephants to be sent from here to put down this wild one. And they sent 2 other persons in order to oversee Grant. Grant asked for a transfer and went to Calcutta, where he served as a distinguished judge for about 20 years. After which he came back to Bombay, got a hero's welcome, left and unfortunately died back on his way home. So this, interestingly, was incident number 1, which illustrated the telling words of Alexander Hamilton, that unless the executive branch actually enforces your order, you are nowhere. We now go back to the United States. All this happened in the year 1828 in Bombay, incidentally. A few years later, in 1834, the US Supreme Court, consisting of its greatest Chief Justice, John Marshall, was approached by the Cherokee Indians. Now, this was a small Red Indian tribe who, by a treaty with the United States, was told that its territory in the state of Georgia was inviolable.